Well, thank you all for being here. I'd like to begin, first of all, by acknowledging the work of the late Ron Ellis, upon whose legislative proposal my Fewer Backlogs and Less Partisan Tribunals Act is based. Ron passed away last December. He was an administrative and labor lawyer, an administrative justice scholar, and reformer. He was the founding chair of the Workplace Safety and Insurance Appeals Tribunal, co-founder of the Society of Ontario Adjudicators and Regulators, and a founding member of Tribunal Watch Ontario, with whom we've been working over the past year. So I'm just standing on the shoulders of giants here. I'd like to start with some stories. I think the first time this issue, the inability to access justice because of long delays at the Landlord and Tenant Board, got my personal attention was when my old grade 8 teacher phoned me one night to ask for help. The rental property that he put his savings into had a tenant who wasn't paying rent, and he was at wit's end. When knocking on doors in my community of Kingston, I chatted with a single mother renter who had to put up with a disruptive tenant in a basement apartment. I spoke to the recently widowed wife of a friend who had their savings in a second house where 6 months prior, the tenant stopped paying rent. The same month, her husband died. The Ontario Ombudsman's Administrative Justice Delayed Report in May of 2023 documented a case where a tenant facing, quote, black mold, inadequate heat, leaks in the windows and sink, and a malfunctioning stove, filed a case in December of 2020. She was forced to leave her home of 8 years in May the next year, 2021. And then she didn't get heard until January 2022, more than a year later, but didn't actually get heard that day because there were too many hearings on the scheduled day. She got further delayed in March 2022 when she had a chance to be heard because the presiding member of the Landlord and Tenant Board was due to leave the board soon because her term was ending, and thought there was too much evidence to be reviewed before the end of their term, so they still didn't get heard. And I also remember having lunch with 4 lawyers who all said that you had to try hard to stay away from the Ontario Human Rights Tribunal because of multi-year delays there. So that's not a great place. That's not a great thing for a place that you can go to seek redress for harassment and discrimination here in Ontario. All of the busiest tribunals, the Landlord and Tenant Board, the Human Rights Tribunal of Ontario, the License Appeal Tribunals, Automobile Accident Benefit Service, and the Social Benefits Tribunal, they haven't been working properly. Together, they handle over 100,000 cases every year. So what are the causes of these problems? Well, tribunals stopped working properly because they were short of members, short of experienced members, and short of experienced leaders. The Landlord and Tenant Board, the Social Benefits Tribunal, and the Human Rights Tribunal of Ontario, they lost about a third of their members, people who hear cases, between 2018 and the start of the pandemic. Experienced adjudicators appointed by the previous government were not reappointed en masse, breaking a precedent. Governments haven't done a good job of filling empty spots on tribunals quickly. So here are a couple things that this bill does in response. First of all, it creates an independent group, the Adjudicative Tribunals Justice Council, whose chair is an officer of the legislature, whose members are appointed not only by the Attorney General but also independent legal organizations. The council monitors all aspects of adjudicative tribunals. It advises Cabinet, can report directly to the legislature, and has the powers granted by the Public Inquiries Act to conduct inquiries. The council must approve tribunal-specific recruitment plans for new members. That includes the composition of the selection committee specified by the plan. The council is mandated to proactively draft recruitment plans. The goal is to make tribunal appointments merit-based, whether or not there is a party affiliation, and to speed up appointments. The practice of reappointing tribunal members whose reappointment is recommended by the chair of the tribunal is formalized. That was the practice in the past, and we're formalizing it. If a tribunal's member's term is not renewed, 6 months' notice must be given, and if the reason is not for cause, the tribunal member may apply to the council, this new council, for a review. If 6 months' notice is not given, the term is extended until 6 months after the minister notifies the member that their term will not be renewed. Regardless of the 6 months' notice, the member is authorized and required to complete their outstanding decisions. That goes back to the tenant who didn't get heard because there was so much evidence, and the landlord and tenant board member said, my term is ending. I don't want to hear this case because I'm not going to be able to have enough time. The goal here is for experienced and competent members to be reappointed regardless of the party in power, and to make tribunal appointments more attractive for people who want to make use of the experience they have with a career move. These are just some of the measures this bill implements to give you a flavor of what the bill tries to accomplish. Let me say just a few things in conclusion. If governments stop leaving vacancies while waiting for like-minded or patronage appointees to tribunals, we'll be better served. You don't have to look further than the distress caused by long delays at the landlord and tenant board. Tribunal appointees may have partisan affiliations, but if they lack the competence or experience needed, that's when the functioning of our justice system is hurt. Ontarians deserve accessible, expert, inclusive, timely, impartial, and just resolutions to everyday legal disputes, the ones that are heard by tribunals. Now, we have some speakers today, and before I introduce the speakers, I just want to thank all the other people who provided input on this bill, including a former Attorney General, a former Deputy Secretary to the Federal Cabinet, the Federation of Ontario Law Associations, other legal organizations, and people who have worked in Ontario tribunals. I also want to say that MPP Lucille Collard is a co-sponsor of this bill. She's our Ontario Liberal Caucus critic for justice. She couldn't join us today. We have MPP John Fraser, who's a co-sponsor and vice chair of the Standing Committee on Government Agencies. That's the committee that can review some of the appointments to tribunals. MPP Stephanie Bowman is a co-sponsor of the bill. We also have Noel Semple here, who's a professor of law at the University of Windsor. He studies access to justice, and he has published on Ontario tribunals and helped in the drafting of this bill. And at the end, we have Kathy Laird and Gary Yee of Tribunal Watch Ontario. Tribunal Watch Ontario was very helpful in providing comments and suggestions as we drafted this bill. So first I'll ask if MPP John Fraser would like to say a few words.
Thank you very much, Ted, and thank you very much for doing this bill and offering your colleagues to support it. Access to justice is critical. These administrative tribunals are critical to people's lives. They're as important as some of the decisions that are made in court. And so that we have a functioning system where people can get redress in a timely fashion is very important. And I know we've got some other speakers here to say a few things, so I won't be too long, other than to say every member in this legislature has a story about a tenant who hasn't been able to get justice for a landlord that's not treating them properly. And they have a story of a small landlord who's put their life savings into a property, and they have a tenant who's just decided not to pay them. People should get access to justice in a timely fashion so that their lives are not turned upside down. And that is the most important outcome of this bill. Thank you very much, Ted.
Thank you very much, John. And now, Professor Noel Semple.
Thank you, Ted. And this is such an exciting day to have this bill before the legislature, and I do hope that all of our representatives will support it. You know, access to justice to me is about whether all of these laws that we create are just words on a page or whether they're real things that people can take advantage of and use in their day-to-day lives. And tribunals have historically been at the forefront of making sure that the law is more than just an empty promise on the page. Tribunals, when they're working properly, offer real access to real justice in a speedy, efficient, inexpensive manner, and they let people achieve that justice even without the benefit of lawyers representing them. And tribunals in Ontario did that for many decades, but unfortunately they became politicized and they were purged by the most recent government, and the consequences are devastating. people are familiar with the Landlord and Tenant Board, and that's extremely important. The Human Rights Tribunal is equally important. Perhaps another one that people may not know as much about is the License Appeals Tribunal, which hears disputes about insurance benefits. If someone is in a motor vehicle collision, this is the body you go to if you can't reach an agreement with your insurer about what benefits you're entitled to. And unless these entities function properly, then we do not have the rule of law in Ontario, and we just have laws that are empty promises. This bill is well thought out. It draws on many decades of research, and Ted and his team have done an absolutely fabulous job about thinking through everything that's necessary to put tribunals on a sounder footing and make sure they return to the promise they've always had of providing real access to justice for Ontarians. So thanks again, Ted, for bringing this forward, and I do hope it becomes part of our law very soon.
Thank you, Noel. And then finally, before questions, we have Kathy Laird and Gary Yee of Tribunal Watch Ontario, who will come up and say a few words.
Thank you, Ted. We really appreciate your private members bill. I think it will bring a lot of change that's needed here. You know, before I retired a few years ago, I had spent 3 decades in the Ontario and federal tribunal systems. And I've seen that any change in government, regardless of the party, it often leads to many experienced tribunal members not being reappointed. But I have not seen anything like the current situation in Ontario. If we look at the Tribunals Ontario mega cluster, we see 7 of the 9 senior appointees have clearly partisan political connections. And the top 2 leaders are a former federal conservative candidate in 2019 and a former vice president of the Ontario PC party. Now, to be clear, just because you have partisan political connections doesn't mean you cannot be appointed to a court or a tribunal. But when there's this kind of pattern with so many politically connected senior appointees, you know, this can just so easily create a negative perception that taints all the appointees and also the tribunal. Now, we've actually more recently seen some, more qualified and less politically connected appointees. But that's mostly at the lower level, and frankly, the damage has already been done. The fundamental problems for tribunals is that we are misunderstood. And so we end up lumped together with all these other agencies, boards, and commissions that do not provide justice services, maybe operational or advisory or investigation, enforcement, and they have government appointees. Tribunals are not like those agencies and boards. But what happens is that every election cycle causes huge turmoil for tribunals. And this vicious cycle just has to stop. Our political leaders of all stripes have to treat adjudicative tribunals as part of our justice system. Tribunal members have powers and responsibilities that are very similar to judges. We hold hearings, we assess evidence and facts, we apply the law, not government policy or statements by politicians. We apply the law, we interpret and apply the law, and then we make binding decisions that affect many individuals and communities. We would not stand for election cycles and election outcomes to interfere with our courts, and nor should we accept that for our adjudicative tribunals. As part of the systemic change that we need, Tribunal Watch Ontario has proposed the creation of the Adjudicative Tribunal Justice Council, and we're very happy to see this reflected in MPP Sue's bill. You know, as he had so graciously acknowledged, one of our Tribunal Watch's founders, the late Ron Ellis, had envisioned this council as an independent body, nonpartisan, that would oversee the administration of tribunal justice in Ontario. This is actually all part of a bigger strategy, a strategy to build a strong public understanding and consensus about the foundational principles for tribunals. We have to make independence and depoliticization such a strong part of defining, it has to be a defining characteristic of tribunals, like it is for the courts. And only then can we withstand any attacks from changes in government or other political forces that frankly, and I don't think I'm overstating this, because of our current political climate, that frankly may be a threat to the rule of law and our democracy. Thank you.
Thanks, everyone. I just want to say that Tribunal Watch is thrilled with this legislation. We're thrilled that the Toronto Star came out in support of an adjudicative tribunals Justice Council just last week. We think this is a turning point for justice at Ontario tribunals. I just want to say a few things to put the situation in context. Already we've had several speakers speaking about the Landlord and Tenant Board and the turmoil there. It's hard to tell you anything you don't already know about what's bad at the Landlord and Tenant Board these days. A couple of things I want to mention. Tribunals Ontario, where the Landlord and Tenant Board and the Human Rights Tribunal are both located, Tribunals Ontario is the most complained about organization in Ontario, according to the Ontario Ombudsman in an October 23rd report. The situation has developed in large part because of what everyone said today, the turnover in expert adjudicators and expert leaders at the tribunals. Trying to think of something new to say about the Landlord and Tenant Board, it might surprise you to know that it now takes twice as many adjudicators to deal with the same number of cases. In 17-18, there were 54 tribunals in place, and they dealt with an average in those years of over 80,000 cases a year. Last year in 2023, it took over 100 adjudicators to handle the same number of cases. The Landlord and Tenant Board now has 133 adjudicators compared to 54 adjudicators before. So that's your tax dollar at work. And even with those adjudicators, the backlog grew in 2023. And just so you understand the depth of the problem, while that backlog was developing, the Landlord and Tenant Board was getting thousands fewer applications every year. Cumulatively, 57,000 fewer applications in the years since the pandemic. And that's when it grew, the 54,000 case backlog. I just want to talk, that's a tribunal in deep crisis. I just want to talk a little bit about the Human Rights Tribunal. I know we're running out of time. The Human Rights Tribunal deals with complex jurisprudence that overlaps with the case law that develops across the country under the Canadian Charter of Rights. The tribunal lost virtually every one of its well-recognized expert adjudicators when the Conservative government came in, and it lost its leadership. The backlog at the Human Rights Tribunal has now doubled. It's a 3-year-long queue. I recently spoke to an applicant who waited 6 years for her human rights complaint to get to a hearing. It never did get to a hearing. Her complaint disappeared into what she described as a black hole, wide and deep. She filed in 2018. It was a serious sexual harassment complaint about a series of incidents at the workplace. Things were so bad that she quit. For years at a time, she got no response to her inquiries to the Human Rights Tribunal about the status of her application. After 6 years, in 2024, she decided to settle because there was still no hearing date. She'd been hoping all along to get an order that would require anti-harassment and anti-discrimination policies and training for her harasser and for the manager that stood behind him and protected the harasser. And she was hoping to protect other young women in the workplace. But 6 years later, that was no longer possible. Those men had moved on to other jobs. And so she settled her case. This case is not unusual. There are dozens and hundreds of similar stories. This is a tribunal that has lost its way, and to a large degree it's because the panel of expert adjudicators and the experienced leadership that was in place when this government took office, they are all long gone. This is no way to run a tribunal, and this is why this legislation is so important. And we're really thrilled that this is going forward and hope that it will get all-party support. Thank you.
Thank you, Gary. Thank you, Kathy. And we have time for questions. I think we have about 9 minutes for questions.
Ted, in terms of the fewer backlogs part of the Act, I can see a way that this bill would be challenged by saying, by adding more oversight, more accountability, it could take longer for people to be appointed. So why wouldn't that be a negative impact?
So very good point. It is the intent, the way the legislation is written, to try to not add another layer of considerations. So the council that's established has the mandate to proactively produce these recruitment plans for new members to tribunals. So they and as I said earlier, that includes the selection committee. So they're supposed to have these recruitment plans ready, and they will be responsible for making sure that these recruitment plans result in merit-based appointments. So the minister's office is not going to have to bother with doing all sorts of background research on people to see what their partisan affiliations are. Or it'll just be based on a selection committee who looks at the merits of the appointees, makes a recommendation to the minister. So I see if things are, I see that things could actually go faster this way.
And how would it work with I think it's the Public Appointments Secretariat? Would that body and its process be taken out of the equation under this bill, or how would they work together?
I think it would just have to work within the constraints of the bill, and some of the powers will be given to the council. Like the council has to approve selection plans. The council will be giving advice to the minister. I would hope that there would be less work done looking into people's partisan backgrounds, just because the council won't let them.
Are there? Is this sort of council? Are there other jurisdictions in Canada or otherwise where this sort of thing exists that serves as an example?
That I don't know, but maybe one of the other people who have more experience could tell me about other provinces.
I can't speak to the details, but Quebec does have something similar and has for many years, and it's working very well. And a key part of the issue that you raised about adding delay is that under this proposal, you wouldn't see adjudicators lost when a government is changed. There would be protection based on performance for adjudicators that were doing their job. So that would end turnover that we see that is really the cause of the delay. Ted said a third of adjudicators were lost, but really at some tribunals, every single experienced adjudicator was gone, and then the numbers remained low for a long time. And right at the beginning, very unqualified people were appointed to some of these tribunals with significant partisan and Conservative Party ties. So, it undercuts the morale and undercuts the morale of staff as well. When they see that people are being rewarded not based on their skills, but based on their affiliations, it means that the whole job isn't that important. And then when you add to that the backlog pressure, the pressure on these adjudicators to get rid of cases, then you have a situation where tribunals like the Human Rights Tribunal, I don't know, I like to say they're kind of flushing things down the toilet. The rate of dismissal at the outset has doubled, and claimants are walking away from their cases in unheard numbers, 3 times the rate, because their cases just sit around and there's nobody that will give them a hearing. So, sorry, I went on a little bit of a rant there, Ted.
Sure,
So
yes.
could I just quickly add, let's pay more attention to reappointments. We always think about appointments and partisanship, but look at reappointments, especially for a full-time member. You're facing reappointment in half a year. You have the leadership dominated by the by the government's political party insiders or connected people. The government's a party before you in the tribunal. I mean, I do believe tribunal members are principled, no matter where they come from, which party, what their background is. I've seen that. They are principled. They want to do justice, but it's the appearance. The appearance of independence is deeply threatened when you have politicized tribunals in the same way that if you have politicized courts, like in the United States. So we have to invest in these institutions as justice institutions, not as patronage and plum appointments every time the government changes hands. Tribunals have to be more respected and understood in that way.
Just one thing really quickly on the point about delay. So there's a 60-day clock also in the bill, right? So the government has to respond to recommendations for appointment in 60 days.
Right, yeah.
So.
Yeah. Yes.
Opinion, how fundamental a shift would this be for Ontario's tribunals?
It's in the past, it was the practice for people to be reappointed if their chair recommended it. So you could ask the question, well, why didn't this bill come earlier? It's because in the past, reappointments were made on the basis of a recommendation from the chair, and we didn't have all these vacancies to fill, and so it didn't reach a crisis. I think, so in terms of practice, we may just go back to what the practice was in the past. I think the fundamental thing is that there's a separate independent body that is going to monitor everything about how tribunals work. And I think if things are working well, they won't have that much work to do. So it's not really... I'm trying to answer your question in a way to say it is fundamental in that we're establishing a new officer of the legislature, but it's not fundamental in that if things are working well, the council doesn't have to do that much. Okay. If there's no other questions, I want to thank everybody for being here today.